My name's Tom Merrills. I'm a solicitor at TJM Law Solicitors, and I'm going to talk now a little bit about right to manage. Firstly, who qualifies for right to manage? The right to manage has been set up in the legislation to enable owners of flats in a block of flats to manage their own building in terms of insurance and other management obligations contained in the body of your lease. Most blocks or buildings qualify, save where there is a commercial part of the building. So if there's a shop at the bottom of the building, if it represents more than 25% of the total floor space in the building, then unfortunately the building doesn't qualify. But if the commercial premises is less than 25%, then the building does qualify. Additionally, at least 2/3 of the total flats in the building must have originally been let on long leases. So in other words, at least 66-67% of all of the flats in the building must have been granted for a term of 21 years or more when they were originally granted. You can see therefore that most blocks of flats will qualify so far as the building is concerned. The next thing to establish is that at least 50% of all flat owners must participate. So for example, if you've got a block of say 17 flats, then at least 9 of those flats must participate in order to move forward. What happens next is that a right to manage or RTM company must be set up, and once the company is set up, we must then serve notices on all of the non-participating flat owners, if any. Once the notices of invitation have been served on any of the non-participants, then it's next to serving the notice on the freeholder, but you have to wait for at least 14 days to pass between serving the notices on the non-participants and then serving the notice on the freeholder. Once the main notice is served on the freeholder has then a month to respond, and they must respond with a counter notice either accepting or rejecting your right to manage. Now what happens in practice is that the freeholder responds with a counter notice simply accepting that you have the right, or they don't respond with a counter notice at all. Now, if they don't respond with a counter notice, it doesn't matter, it's the same as responding with a counter notice that accepts you have the right. In other words, there is no sanction on the freeholder for failing to reply with a counter notice. What it does mean is it sets the date for the acquisition of your rights to manage, and that will usually be approximately 3 months after the counter notice date. So in other words, the whole process from beginning to end generally takes about 4.5 to 5 months, depending on the number of flats that are participating. During that 3-month window, whilst you await your rights to manage, we can ask the freeholder for details of any funds held in a sinking fund on account of service charges, and you're entitled to have that fund transferred over to the right to manage company on the acquisition date. We can also ask for details of any contractors that the freeholder currently contracts with, as you may wish to take up those contracts, but you don't have to take up those contracts afterwards. You're under no obligation whatsoever. So what sort of obligations do you take over from the acquisition date? Well, essentially you look to the terms of the lease, and typically the things that you will take over are the insurance of the building, maintenance of the building, gardening, maintaining the roof, guttering, and all other types of repairs. And you can even either appoint your own managing agents to do the job for you. The benefit here is that if they're not up to scratch, then you can effectively sack them and choose another managing agent, or which is not advisable for blocks of say 5 or 10 flats or more, but you can take over the management yourselves, i.e. the directors of the RTM company can contract with say gardeners or roof repair specialists, etc. yourselves, and just get the work done on an ad hoc basis. Acquiring the right to manage is often seen as a alternative to buying the freehold, simply because it's cheaper and quicker. Certainly there's no purchase price to pay because you're not acquiring any legal title as such, you're just exercising your rights under the legislation. One of the benefits with buying the freehold is that you no longer pay any ground rent to your freeholder, which you would continue to have to do so with the right to manage. And also with buying the freehold, you completely rid yourself of the freeholder. So for example, if you just exercised your rights to manage, then if one of the flat owners wished to make internal alterations to their flat, they would still need to seek the consent of the freeholder. If you bought the freehold, however, you would just essentially be asking for permission from yourselves collectively. So that is right to manage in a nutshell, in terms of the process and the qualifying criteria. If you've got any further questions, you can either email me direct or using our Get in Touch page on our website, or even posting on the forum on our website. I'm Tom Merrills of TJM Law. Thank you very much for watching.